Hello, my name is Peter Kempner, and I'm the Legal Director at Volunteers of Legal Service, also known as VOLS. I oversee the work of our Elderly Project and our Veterans Initiative, and I'm here to talk to you today about planning for your future. When we talk about planning for your future, we want to make sure that our clients have the right documents in place so that their wishes are clear and their wishes are being carried out by the people that they love and they trust the most. We split this into two categories: documents that are important during your lifetime and documents that are important after you pass away. First, to give a brief overview of these documents, the documents that are important during your lifetime include the durable power of attorney, the healthcare proxy, and a living will. The documents that are important after you pass away include the last will and testament, and an appointment of agent to control disposition of remains. One important note about many of these documents is that you need to appoint an agent. Some of these documents, like the power of attorney, the healthcare proxy, and the control of remains form, require the appointment of an agent. These documents cannot be obtained or executed unless you have identified somebody to act as your agent. On the other hand, the last will and testament and the living will do not require the appointment of an agent. You could still obtain these documents even if you don't have anyone to name as an agent. So let's first talk about these important documents for during your lifetime. What we're talking about here is having a plan in place if you're ever to become incapacitated. We'd like to think about two different categories of affairs that we want to make sure that you have agents in place to take care of for you in the event that you become incapacitated. The first category is financial. And for financial affairs, we recommend that all clients have a durable power of attorney. The durable power of attorney is a very powerful document that gives power to another person, known as the agent, to make property, financial, and other legal decisions for you. In this document, you're called the principal. It allows your agent to pay bills on your behalf, apply for benefits on your behalf, and engage in other financial transactions as well. What happens if you don't have a power of attorney? If you become incapacitated and unable to perform financial transactions, someone may have to petition the court for legal guardianship over you in order to act on your behalf. This is potentially a long process, a costly process, and an invasive process that strips you of your legal autonomy if a guardianship is granted. Potentially, your bills will go unpaid, your renewal leases will remain unsigned, and you'll be at risk of losing your government benefits and other benefits until a guardian is appointed, if one is appointed. The next category of affairs that you want to make sure are handled during your lifetime is healthcare choices, and who will be making healthcare decisions for you if you cannot make those yourself. The first document that we recommend that people have in place is a healthcare proxy. The healthcare proxy is a document where, again, you are the principal and you name another person as your agent, and that person will step into your shoes and make medical decisions on your behalf if you cannot make them on your own. What happens if you don't have a healthcare proxy? If you become so sick that you're unable to communicate with your medical providers, they may then turn to your closest relative, as determined by state law, to make decisions for you. That relative may not be the person who you trust the most to make your healthcare decisions. And if a relative or close friend cannot be located, decisions about your healthcare will be made for you by your healthcare professionals. Their decisions may or may not reflect your wishes. And so we believe it's very important to have in place a healthcare proxy that clearly names an agent. And this agent is somebody that you've discussed with in advance what your philosophy is on medical interventions. Sometimes people don't have an agent to name in a healthcare proxy. And in those situations, you could prepare a living will. In a living will, you explain what treatments and care you do want and what you don't want at the end of your life. The living will does not name a person to make decisions. Instead, it lays out for your medical providers what treatments you want or don't want. What happens if you don't have a living will? Absent clear written instructions stating otherwise, and in the absence of having somebody acting as your healthcare proxy, your healthcare professionals are under a duty to keep you alive by any means necessary. Another advantage of having a living will is that it could be used to inform your agent under a healthcare proxy about what kind of treatments you want and what you don't want if you ever find yourself in a terminal condition. Now I want to move on to documents that are important for after you pass away. And the first document I'm going to talk about is the last will and testament. In your last will and testament, you state who you would like to inherit your property. This includes the content of your apartment, your money, any real estate you may own after you pass away. In it, you name a person who's called your executor to protect your property until debts and taxes have been paid, and then they ensure what's left goes to the people who are named in your last will and testament as your beneficiaries. What happens if you don't have a last will and testament? The state then will decide who gets your money and your property after you die. When you have a last will and testament, that document is submitted to the surrogate's court for a process called probate. But when you don't have a last will and testament, your estate is then submitted to the same court, the surrogate's court, but now that process is called administration. The person who's named to be in charge of your estate in the administration process is called an administrator instead of an executor. I want you to take a look at the language for a second of last will and testament. When you look at the word testament, it comes from the word testify. And when you testify, you speak your mind. You say what you want. And if you die without a last will and testament, we say you have died intestate. You failed to speak your mind. And so then the intestacy statute kicks in, and that will decide who gets your property and your money after you pass away. Both processes are potentially time-consuming and costly for your heirs, but administration could take longer because then the court will be forced to track down who your heirs at law are when you haven't clearly spelled that out in a last will and testament. You also won't get to choose who the executor is, and instead the court will determine who the administrator is and who is responsible for distributing your money and your property in accordance with your wishes. The last document I want to talk about is the appointment of agent for the control of the disposition of remains. We also call it the control of remains form. In this document, you name a person to handle the disposition of your remains. That is your burial, your cremation, if you've chosen to donate your body to science, and whatever funeral arrangements you would like. In this document, you could include very specific instructions and information, such as the location of your burial plot or where you would like your ashes to be scattered. This is especially important if you've made any pre-arranged or prepaid funeral or cremation agreements. You could again lay out in this document not only what your wishes are, but also whatever prepaid or prearranged agreements you have. And so that way your agent under the control of remains form could have a clear indication of what to do after you pass away. What happens if you don't have a control of remains form? You will not have control over who retrieves your remains, nor will you have control over what that person does with your remains. Some people feel very strongly that they don't want to be cremated, but if you don't lay out those wishes in advance, you won't be able to prevent that from happening. Volunteers of Legal Service Elderly Project and Veterans Initiative serves New York City residents age 60 and over who have very low income and limited resources. We help draft and execute these life planning documents for our clients and provide legal counsel on a wide range of civil legal issues. If you believe that you might be eligible for our services and you're interested in having these documents done, please give us a call to speak with one of our attorneys. For seniors, you can call 347-521-5704. And if you're a veteran, please call 347-521-5725. You could also email us at lifeplanningdocuments@volsprobono.org. If we're unable to answer your call, please leave a message with your name and your phone number. And please be patient. Due to high call volume, it may take us a little while to get back to you. Thank you for listening, and please take care and be safe.